Welcome to the Supreme Court Podcast. Are Sharia courts autonomous bodies which do not need to lean on regular civil courts? This was discussed by the Supreme Court in the cases Spouses Maliga versus Spouses Tingao and Spouses Maliga versus Unte, GR numbers 211089 and 211135. In this case, Annalyn got two separate loans from Dimasurang and from Spouses Tingao with monthly interest of 25% and 10% respectively. Annalyn's husband, John, later learned about the loans, finding that Annalyn had paid Dimasurang over 8 million pesos for interests alone, despite the principal amount of her loan being only around 1.9 million pesos. Annalyn had also paid Spouses Tingao over 1 million pesos for interest alone, despite the principal amount being only 330,000 pesos. John told Annalyn to stop the payments, but the lenders continued with their demands. Annalyn and John filed a complaint with the 5th Shari'ah District Court in Cotabato City against the lenders, asking for the extinguishment of the loans and refund of all overpayments. But the Shari'ah District Court dismissed their complaint, despite the parties being Muslims, saying it lacked jurisdiction over their case as it involves the application of the Civil Code and usury law, not Islamic law. The Supreme Court, however, ruled that the Shari'ah District Court has jurisdiction over the complaint. The court ruled that the Muslim Code does not limit the Shari'ah District Court's jurisdiction over actions involving the Muslim Code. On the contrary, the catch-all provision in Article 143, Paragraph 2, Subparagraph B of the Muslim Code grants Shari'ah District Courts jurisdiction over nearly all personal and real actions between Muslims. Thus, regardless of the subject matter of the action, the Shari'ah District Court may exercise jurisdiction so long as both or all parties are Muslims. The court added that while Sharia courts may be courts of limited jurisdiction, they are expected to have the same proficiencies and competencies as regular courts, considering that Sharia judges also possess the qualifications for judges of regional trial courts. Thus, in addition to their specific expertise in Islamic law, Sharia district courts are equipped with the same capabilities as regular courts. This is further amplified in the organic law for the Bangsamoro Autonomous Region in Muslim Mindanao, which vested Sharia district courts with exclusive original jurisdiction over all other personal and real actions involving Muslims. Thus, actions where the Sharia District Court previously had concurrent jurisdiction with regular civil courts are now considered within the exclusive and original jurisdiction of the Sharia District Courts in the Bangsamoro Autonomous Region. In the case of Annalyn and John, the court said that the Sharia District Court should not have dismissed their complaint simply for perceiving it did not involve any applicable Muslim law, especially since the complaint actually invoked the last sermon, where the Prophet Muhammad echoed a portion of the Quran, the ultimate source of Sharia, which prescribes riba, or the receipt and payment of interest. Annalyn and John should have been given the opportunity by the Sharia District Court to present evidence on the invoked last sermon and to argue its relevance to their case. The case was thus remanded to the Sharia District Court, with the Supreme Court stressing that Sharia courts are autonomous bodies which do not need to lean on civil courts. The case was thus remanded to the Sharia District Court, with the Supreme Court stressing that Sharia courts are autonomous bodies which do not need to lean on regular civil courts, consistent with our collective aspiration of equal and inclusive justice. To read the full text of this case, visit the Supreme Court website and search for the cases Spouses Maliga versus Spouses Tingao and Spouses Maliga versus Unte, GR numbers 211089 and 211135.